which is aimed at bringing information on estate administration to your doorstep. Before we continue, let me introduce our guest, our speaker on this occasion, person of Mrs. Folarin Williams. She is a chief magistrate, the HOD of Lagos State High Court. This is Folarin Mobolani. You are welcome.
Thank you so much, everyone. Good morning. Not HOD of Lagos High Court. Okay. HOD of Lagos Probate. So we have two sections of probate in Lagos State: Ikeja Probate, Lagos Probate. So I head the Lagos Probate. Thank you for having me. I'm sure we're going to have a nice time together today. Thank you.
Thank you. Most welcome. With me also is Ms. Dupe Akambi. Ms. Dupe Akambi is the head of First Registrar Company Secretary and Probate Services. She's a very, very eloquent and very, very good person. Ms. Dupe Akambi, you are welcome in our midst.
Thank you so much for having me. Thank you.
All right. I want to quickly read the profile of our guest, this speaker. Mrs. Omobolani Folarin Williams began her education in Mayflower Primary School and proceeded to Federal Government Girls College for her secondary education. She earned LLB degree from City, now and later obtained a BL from the Nigerian Law School, after which she was called to the Nigerian Bar. During her youth service in Kwara State from 1993 to 1994, she worked with the Legal Aid Council and received a certificate of qualification from the National Youth Service in Kwara State for her industry worker. In December 1994, she joined the church later, working in the legal department. In 2000, she joined the Lagos State Government State Council, rising to the rank of Assistant Chief State Council before being appointed as magistrate in July 2009. She is now the Chief Magistrate and currently serves as the Chairman of the Magistrate Association. Igbo Christian and an ordained pastor, she knows integrity as her core value. She believes in making a person. Once again, madam.
Thank you so much, Mr. Adeoye. Sorry, my voice is cracking, just bear with me. Let me also correct something there. I'm no more the chairman. And I do by in April. Let me correct it. That was it. I've corrected that.
All right.
Thank you. So once again, good morning, everyone. I'm happy to be here. And I'm so happy that you have brought up this topic, so important, and something we are passionate about in Lagos State. So as we go along, I want to be very, very interactive. Ask your questions, please. Wherever you are not clear, just let me know, and I will make us understand what we do in probate, how you can access our services easily, and whatever challenges you've had, at the end of today, I believe everything will be sorted out. Yes.
Thank you so much. At this point, I think I'll be handing over to the Dupe Akambi that will take you up from there. Thank you.
All right, thank you so much, Aaron, for that introduction. And once again, you are welcome, Mrs. Folarin Williams. It's such a privilege to have you with us, and we don't take it for granted. So, as much as possible, we want to make this session an interactive one. So this is the way we are going to go about it. We'll be asking questions relating to probate services, relating to probate administration on your behalf. And as we do that, we would want you to just send in your questions, or if there are areas that you need clarity on, let us know so that we can put the questions to our guest speaker, and then we'll take it from there. So, Madam, to start with, can you please explain to us what probate is and why is it necessary in the estate settlement process?
Well, thank you so much. All right. Life can happen to anyone. Nobody should be afraid of death anyway. So it will definitely come one way or the other. And once somebody dies, the family members naturally should be able to assess whatever the person has left behind. Very, very important. You should be able to do it. Not only to do it, but to do it easily. To do it easily. And that's why we are there. For Lagos State, I can tell you the notion that people have that, oh, it's so difficult, I'm not interested, let me just leave it, I can go and do something else, I won't die if I'm not able to access my father's properties or what. No, that's not the way it is anymore in Lagos State. Things have changed. Once somebody dies, as the children or the spouse or relatives, you have the right to come to us and tell us what has happened, and then put in your papers. They will assist you to process everything so that you can, on your own, now deal with the properties that deceased has left behind. Okay, so, like I said earlier, Lagos has two sections. We have Ikeja probate, we have Lagos probate. But you can process your documents anywhere. You can go to Lagos probate or Ikeja probate. For now, we both reside at the High Court in Lagos State. For Lagos, ordinarily we should be at Igbosheri, but unfortunately the NSAS issues on the High Court got burnt, so we had to move to Ikeja for now. All right. So when you lose someone, naturally everything devolves on those who are the deceased personal representatives. And who are they? For us, the first person is the spouse of the deceased person. Next, the children. Next, the parents, the siblings. Then others can come in, aunties, uncles, and things like that. All right, good. So let's start. Somebody has lost someone. What do? There are two ways. Sometimes people have left their wills, they wrote it before they died, and it is lodged with us. So if you come to us, wills are lodged with us. So you can lodge a will with us even before you die. So sometimes wills are lodged before death, sometimes they are lodged after death. So if you died with a will, you can come to us, let us know you have the will lodged with us. And if you don't, come and lodge it after the person has died. There's a fee you have to pay for that. You lodge your will, like 10,000, not much. But if you lodge it after death, within 3 months, I think it's still 10,000, but after 3 months, it can be, I think, 50,000. It's not really much. So for those who have wills already lodged with us, and let me say something, please, at any time you lodge your will, please keep the receipt that you were given. Sheet of payment is very, very important, please. Very, very, very important. So keep that receipt with you, because whenever you come to us to access that will, that's the first we're going to ask you. Where is the receipt that was issued to you when you lodged the will? All right, so let's start with those who died with having written their wills. For those who died without wills because they died intestates. Good. So now you have a father or a mom or anyone that died and left a will before they died. So after death, if the will is already lodged with us, you come to us, the first thing we're going to trash out is reading the will. We must read it to know what is there. So the person that lodged that will come to us and tell us the person has died, we want the will to be read. So you also pay for that. And let me say something. If peradventure you have people who don't even reside in Nigeria, we have online readings. Okay. So for instance, my dad has passed on, so my dad is still alive. Peradventure he passes on, and he has a will. already lodged with us, okay, and I have siblings abroad. So what we do, those of us who are here will come physically to the registry. Those who are abroad, we already give you, you also pay a fee for that, for online reading. So we give you a link. So you send to them, they will also listen, just like we are doing now. They also listen while the will is being read. Because it's very, very important for everyone who has a right to what is there to be in attendance when that will is being read. So who applies for the reading of the will? It could be the person who lodged it. It could be your lawyer. It could be maybe a member of the family who has a right or who knows what is happening in that family. So when the person applies, we give you a date for reading. For us, under Lagos, we read wills on Thursdays. So now there are people who are coming to us in 2 days' time to have their wills read.
On Thursdays.
We usually people are reading on Thursdays. So Thursday is always a very, very busy day for us. We read wills for different families. So they would have applied in writing, and they will put in writing the people that are going to be invited for that
For
reading.
the reading of the will.
Yes, very, very important. And let me say something here. The first thing I want to advise everyone is that please put your house in order. It's not as easy as I'm saying it. Because on the days we're going to read will, sometimes we don't even read the will. Because someone just comes from somewhere and say, no, that will should not be read. No, I'm not aware. I wasn't invited. So know those. It's important for the deceased to have, mention 1 or 2 people. Make sure this happens by the time it's going to be read. Very, very important. So you apply for the reading, you bring and put the names of those who are supposed to be there. So they must come. If, for instance, you have 10 names that must attend reading of the will, and just 3 appear on that day, we won't read the will. Out of 10, only 3 of us won't read the will. And we're going to ask you, why didn't they come? So I can tell you now, we have different ones that have applied, but we have not read, because we need to know where the other people are. I just approved one that generally should be read. Why? Okay, initially they came, they said, let me give practical examples now. So there's a family, they have come up that they want the will to be read. So they brought about 9 names for us, which we approved. On the day of the reading, maybe about 3 or 4 came. Then I will also ask, where is the wife on this list? On that list. Where are the children on that list? Okay. So you start hearing stories. Oh, okay, let me give a practical example. The last one I eventually approved. We were told that one of the children is abroad, has a kind of disease or whatever. A kind of disease. Okay, so what kind of disease? What kind of sickness? So we got to, it wasn't an argument, but I needed to explain to them that, look, even somebody is sick and living abroad, and you're telling me that government is taking care of it, it even makes it easier. So if the UK government is taking care of the person, then let us have details and be sure, So we needed to know why that person did not come on the day of the reading. Also, the wife was not included. Oh, she was included, but she didn't come on the day of the reading. So we didn't read it. Why? Okay, we called her, she didn't come. Sometimes we call people, they don't come. But we must know the reason why they don't come. So what we do, go on social media. Go and put it there. We want to read this will, and you are not here. You are because you didn't come. So we must be sure that those that are supposed to be there, we start from the spouse, the children, and if they are not there, you must convince us why they are not there. Then we move to the number of the people that have come. If you have 10 people that you have told us, if you told us you are bringing 10 people, how come just 3 came on the day of the reading, or only 4 came? So you need to tidy part of that part. Very, very important. Okay, another family that came, they said that, I think the people read the will. Okay, let me leave that. Let's go to, okay, now the will has been read. Now the next thing is, you know what is in the will. You know how the disease has shared its properties. Now the next thing is to start the process of grant of probate. That is the document that will empower you to stand in the shoes of the disease. Because without that document, there are so many things you'll be able to do with the assets the disease has left behind. All right. So the will has been read now. After we in a will, for a will to be authentic, there must be witnesses. You open some wills. When you bring the wills to us, they are sealed. You know those red seals. So we don't even know what is there until we read it. By the time we open the will, I see that they are not signed by any witness. It's not by the will we read it. It's not valid.
So a lack of witness invalidates a will.
Oh, yeah, it does.
So it's a requirement that every will that is created by the testator. The testator has to have somebody who had witnessed two. Is it required that it's two or one person?
Two.
Must be two. So must be signed by those two witnesses.
So if you open the will and it's not signed, then we can't. So, but it doesn't mean you cannot go ahead and obtain what with the paper. I'll mention the name that will entitle you to have access to the properties. But with that, you will do what we call letters of administration, not grant of probate. So there are two things you take from us. If you died with the will in place, you get the document called probate. It's called grant of probate. Without a will, you get what we call letters of administration. So for those who have wills that are not signed by any witness, not witnessed by any witness, so you can't get what you call grant of probate. You get what we call letters of administration. So I'll tell you the difference later when we go ahead. All right, so now eventually the will is in order. We have read it. So we call what each person now knows what belongs to him or her. Beautiful. So now you now start the main process of that grant of probate. That's the document that really now puts you in the shoes of the testator. Yes, it's better understood that way. All right. So there's something we call marking of the will. That means that once the will has been read, in the will you now see the executors. Those are supposed to execute the assets and things like that. They will be named there. At most four. At most four. Even
at most, or at least?
No,
at most.
Even if you put 10 names there, we pick the first four.
Okay.
And let me say something. Once a will is in place, as much as possible, we make sure we go by what the person has put in the will.
Because that is the individual's express will.
Yes, that's what it
his
wants.
Desire.
Yes. Ordinarily, at least two people, but if the owner says he wants only one executor, what do? You have
that
the choice. That's what you want. But ordinarily, you have at least two and at most four.
Okay.
So once the will has been read, now you want to start the process, the main process of getting that document. Okay. So you have to go online two ways. You can go online to access our website. Very easy. www.probate.lagosjudiciary.gov.ng. Create an account. It's better you use your laptop. I don't think it's phone friendly. Create your account and it brings out to you all the services we render. Brings it out. Just click on the one you want.
Okay.
Grant of probate, letter of administration, resealing, double probate, whatever, will lodgement, whatever. Everything stated online. Just click on what you want. So you just pay a fee of 5,000 online, you pay it, you fill your form online. While you're filling it, we are seeing it at the registry. So once you have done that, you now come to us. We print it for you, continue from there. For those who are not computer literate, or maybe for those who are not well read, you can come to the registry directly. You just pay additional fee of 3,500. They will help you fill everything at the registry. So there are some documents that are very, very important you must have. The death certificate is very, very important. Without that, we can't even start anything. And that death certificate, we don't take from any private hospital. We take that from General Hospital or National Population Commission. They are different local governments now, NPC. So you go there. So if eventually somebody died in the private hospital, you can take the death certificate to National Population Commission and they will give you a death certificate to bring to us. So you must have that. That's the first thing you must bring. Okay. So that's the first thing you must bring. And that we will cite the original, we just retain the photocopy. All right, so once you have filled the form, either online or you come to us in the registry, we feel for you. And please note something. It's good we have people like you here who come on behalf of your clients. Anybody can walk in and the registry will assist in, every step of the way what you need to do. Even if you don't have a lawyer. Please, is that good now? Come to the registry, tell us what you have come to do. You have lost somebody, how can you help? They will take you through every step, just the way I'm explaining now. All right, so once you have printed your form, now that form has different parts which you need to fill. There you will have whether the person left properties or not. So you have your form, you print it out. That is where the work starts. And that is where some people feel we delay them at the registry or government takes time to bring out all this. No. When you fill the form, it's called bank certificate. You will go to all the banks where the deceased had money, deceased had shares. You fill the part where deceased had properties also. So if those banks don't fill those things for you on time to return to us, there's nothing we can do. If you don't respond those sets of forms, we can't even go on. Go to first banks, and be different banks where they are. They go to the stockbrokers where they had shares too. So when the form comes back to us, if eventually we give somebody a form on the 1st of June. If the form does not come, as I speak to you, a lot of people have printed their forms, they have filled it, they've taken it to the different places, they have returned the forms. So somebody tells you they don't know what they are doing. That probate, things don't go on well, things don't go on easily, blah 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 and everything. The first I always ask them, have you filled your form? Yes. Have you taken to the banks? Yes. Has it been brought back to us? No. So when the form is brought back, we look at the form. The different banks put the amount of money in the deceased account, put it in the form. Different stockbrokers, they put the number of shares on the form. And then whatever, either you have the property or what is there, they will now calculate, put everything together, we now remove our own percentage, which goes to government. And we pay to government.
So, Madam, yes. I'll just come in here.
Yes.
What percentage does the government take?
Okay, everything put together, it's 10%.
10%.
But now, if you have properties, that's a different thing entirely. That takes a bit of more time than having only shares and money. Yes. So what some people do, they don't do the properties yet. So they can quickly assess the funds. So they do only the money in the bank and the shares first. Because if you have properties now, it has to go to our valuation section. What does that mean? You bring us the pictures of properties, not phone pictures, real
actual pictures.
Good. You're going to the site to check the property, either it's bare land or already built up. They go check there. So, and they use the fair market price to determine the value. Then they now take the commission. That's another thing entirely on that.
So how much is
No, that is not known. Is where you get there.
Until
you get it. Are you aware?
So what I mean is there a percentage or a rate that is usually used?
Until you get there.
Until you get there.
Their own section. Okay, so and also, please don't be scared. For instance, if maybe anybody's deceased father or whatever, when you see had about, let's say 100 million in the bank altogether, all the assets, personal assets, shares, let's say it's 100 million. So 10% will be about 10 million. And you'll be afraid, where do I get that money from? You're going to be afraid. You can write us a letter that you want us to take the money from the bank while we are processing it. Good. So that we do that almost every day. So once you write us, we approve it. So we write to the bank, please deduct 10 million from so-so account. So you don't need to pay that 10 million from your pocket. So the bank will deduct it. Once they know whatever is there, there's enough funds there where you can take that 10 million from.
Is it the same thing for grant of probate?
Everything is the same, either probate or it's of administration.
Okay.
Okay, may I ask a question?
Yes,
then
please.
what if
In this instance, there's no money in the bank. The deceased had only shares.
Okay. If there's no money in the bank, so obviously what you pay might not be much, because even all those shares, some of them, the shares, they might be a lot, but the value is this much. Maybe, for instance, no money in the bank, you have only shares. What you might need to pay might just be, after putting all the shares together, I'm sure whatever the 10% will take will be much. So that you pay yourself. If there's no money to be taken from your account, to pay yourself.
Okay, what if the volume of the shares is like 200 million and the family doesn't have money to pay the 10%? Is there a way that
But those shares, let me ask, those shares, don't they have there are dividends attached to some of those shares?
Yes, those dividends,
money, yes.
those dividends cannot be accessed
until
the whole process is complete.
So
and
what
there's
we do is
transmission.
money in the bank.
Oh, okay.
It's also important, money in the bank.
Okay.
All right. So along the line also, please note that you, apart from death certificate, you get 2 passport photographs of those who are going to be
The administrators.
yes, executors. So for those with wills, we use the word executors. Those who died intestate without wills, we use administrators. Yes, administrators. So 2 passport photographs of the administrators, 6 months bank, 6 months bank statements for the sureties. You know, when you come to us and you tell us that, oh, these are the administrators or these are the executors, they start to bring sureties. Just ask them questions that they know those people. Very, very important. So those sureties, depending on the amount of the estate, we have what we call small estate, just below 100,000. That was almost nothing. What you just pay for the form, and maybe just 1,500 or 2,500, something like that. That's just below 100,000. Okay. Just wonder then, why did the person now go ahead to do that? Let me say something. It's important because even though the person not live much, but somehow that person, the disease might be entitled to something somewhere. You're not just even aware.
Okay.
And if you don't have that document, there is no way you can access it.
Okay. Yeah.
And there's still publication for those who died with wills. There's only for publication because what the person wants, or how the person wants it is an estate to be administered is already in the will.
So stated.
There is no question about that. For those who died intestate, after you have brought your administrators, you have brought your sureties, you have filled your forms, you have returned your forms, you're going to bring 2 sureties. If your estate is above over $1 million, no.
Over $1 million.
If it's below that, you can bring just 1 surety. So the sureties must, for those whose estates, is a large estate, you must have landed property in Lagos State. 6 months bank statements, passport photographs. They just question you, what do you do? Do you know this person?
So I just need to, for the sake of our viewers out there,
Yes.
Are the sureties the same thing as the executors?
No.
They are not. So the sureties are actually people who can vouch for the executors or the administrators.
Yes.
Okay, it's just like what do you call it when you in the financial sector, guarantors?
Guarantors, something like that. Yes.
Okay. So just for the purpose of clarity for our viewers, Madam is saying to us that part of the requirement of obtaining grant of probate and letters of administration is that the executors or the administrators to the estate must provide sureties, which we can also refer to as guarantors, that we attest to and vouch for their credibility and testify to knowing who these people are. Yeah. So, Madam.
All right. So once, if you, for instance, let's say you start the process today, you collect your forms. After we have read the will, you collect your forms, you take to the banks, to the stockbrokers, and you bring everything back. And there is no property attached at the moment. You bring it back to us. Within 4 months, you can have your document. I can tell you that, yes.
Really?
Because once you bring it back, what the next thing we start paying our own internal documents. So within 4 months, you're done.
But can it be shorter than 4 months, madam? I mean, in this day and age with technology, with digitalization of a lot of things in your sector now, one would expect that under a month, give or take 1 month, you should be able to get all these documents.
Let me tell you why it's not possible. Number one, we're going to do publication in the newspaper within 21 days.
Okay.
So it's after there's no objection to publication as we started. And you know, we have people coming in on a daily basis. So we can be treating on a daily basis as many files as possible. So we can't just treat one file and send for signature or go to the next person who's going to treat it. We treat everything. So somebody comes, brings his own form, we start working on it, put it there, next person does. So in all, it's not possible to maybe treat only 10 or 30 files and then send them. We wait and gather more together. Maybe we have about 80 in all, 100 in all. We treat them, send to the next person, comes back to us, then you get your grant. So without the publication lapsing, there's no way you can go ahead.
So that means that once the process starts, part of the requirement is that there should be a publication in
for those
that don't have wills.
Yes.
There must be publication in the newspapers.
Oh, definitely.
Calling for those who
they want to object to that.
Okay.
To the,
so
to the grant.
I hope our viewers are getting what we are saying now. The probate registry publishes the details of the deceased. And the fact that somebody is coming to apply for the letters of administration,
yes.
Particularly where the deceased did not leave a will, that's where it is important to publish in the papers that somebody has come to ask for the letters of administration in this case of so and so. Is there any objection from any member of the public who has interest, maybe directly or indirectly, maybe as a child or children or wives, so that whatever issues may arise thereafter will be taken care of ab initio before the letters of administration are granted.
Also, for some, even with wills, they don't mind you publishing. That's right. So for some, because somewhere they can get to one office and say, okay, where is the publication? Those ones won't understand that there's no need
for
to publish for
a
will.
Okay.
So some say, okay, so publish it, so go ahead and publish it also.
Okay.
All right, so once you bring it back, we publish, comes and then we start our own internal arrangement processes from us. It has to go to a probate judge. You see, that probate judge is a judge who also sits and does his own cases in court. So he has his own duties also. And he's still going to sign bundles of files. So there's no way. So if it's not possible to be done within 3 months, really, but I can assure you, let's say 4 months, fine. But if there's a property involved, it might take a longer process, maybe 5 or 6. Why? Because we'll still go to the site, inspect the property, for assessment, for that purpose. Exactly. And sometimes, once you let people know that we're going to the site to assess, you don't even see them. Okay? So that delays it. Okay. They will tell you, it's been there, the fellow has been there for over 6 months. Ask them when they send them a message, you want to go to the site, when will you be ready? No response, they will not show up. So most of the time, I'm not saying that we don't have any challenge on our own side, maybe for one delay or the other, but I can tell you, whatever challenge we have, we usually overcome it in a short while. So most of the time, it's people who come to us that delay this process because they don't bring back the documents they're supposed to bring to us for us to continue the process. Yes.
Okay, at this stage, I would like to inform our audience. If you have any questions, you can start putting your questions in the chat box and on any of our social media handles. You will find us on Instagram at First Registrars, X formerly known as Twitter as First Registrars, and on LinkedIn we are First Registrars and Investor Services Limited. Also on Facebook we are First Registrars and Investor Services Limited. So, madam,
would you like? So I don't want to forget. So while they are putting the questions and before you ask your next question, please can I just put this out? Try as much as possible, if you're writing your will, to appoint young people as your executors. Please. Because sometimes those you appoint who are your age mates, sometimes some of them will pass on before you. And also, when you're looking for people to be witnesses to your wills, please use those that can be easily located. Please, don't use my neighbor, my tenant. Those ones you can pass easily. But those you know, because sometimes when there's a problem, when there's an issue, to verify something, you look for them, you don't find them, and it will delay
The
your
process.
work. Yes, please. Very, very important.
Yes.
For instance, if you have a will and you pick somebody who is young, maybe your children, or maybe even a relative who is young, as maybe your grandchild, and I can tell you, it pays you better. By the time you're gone, and these ones are just growing, they're easily accessible to us to call to ask one thing or the other. But for some, just like what we are handling now, and that day, Baba is old, he can't come, and they need to
Present themselves.
They need to present themselves. Yes, they need to mark the will. They must come and sign. After the will has been read, you have paid the money, the estate fee. You need to sign. They come and tell me that Baba is old. I said, sorry, that is we won't go ahead. So we make them bring Baba here, bring him to the compound of the High Court. Yes, bring him there. So there's one of the, it's so unfortunate, but there's nothing we can do. They say, you can't even get, make videos.
Video calls.
Because we deal with evidence. Courts deal with evidence. Even though as an administrative court, the registry, but we deal with evidence. So we don't say him. If we can't, we must know, he's actually the person. So please, make effort to use those who are young as the executors. It's very, very important. So they can easily come when they are needed.
Okay, so that brings me to my next question, madam. In very concise terms, can you please explain to our viewers the role of the executor in the probate process, the executor or the administrator? What role does he or she serve? And then we now go from there to the heirs and beneficiaries.
Okay, it's very simple. The executor, that's when you hear executors, it means there's a will in place. So inside that will, the testator must have put there what they will do. They deal with the assets of the deceased person. Pay this, deal with tenants, blah, blah. Their roles are usually not a long-term role. It's even trusting. That's a different thing entirely. Some wills can create a trust inside their will, but for just an ordinary will. So the executors are just concerned with what he has left behind, and then he wants the things to be shared. So once everyone, let's just give a practical example. A man dies, he had about 4 properties, one in Sureties, one in Ikeja, one in Naja, another one in Magodo. Okay, he names the executor in the will, give this. Once that has been done, any debt, maybe any debt that was being owed, once he has been and everything, everybody, just they take whatever belongs to them. The executor has finished his job. But if peradventure, there's a trust, maybe a very rich man who created a trust in the will, then they are trustees. So those ones, their own roles can be almost forever in court. Because a trust is on somebody's behalf. You have to do that. So that also their own duty continues. To make sure that the trust is administered the way the disease should be administered. Gives also, maybe private, there's a business, so maybe with the business that brings in money, gives also person a certain amount of money on a monthly basis. That's a different thing. But once the executor has distributed the assets, paid any outstanding debt, paid any whatever, the job almost finishes. Except you also double as a trustee. Yes. All right. So our website is www.probatejudiciary.gov.ng www.probate.lagosjudiciary.gov.ng. It's better you use your laptop. Then you create an account.
Okay.
So once you go on, you create an account, all our services will just pop up. You can even lodge your will online. Once you
Okay,
lodge
that's beautiful. So
once you lodge
individuals
your will-
can lodge their will online.
Once you lodge your will online, I get my laptop, I say, no, I approve it. You see that it has been approved.
Wow,
Yes.
that is beautiful.
Online.
So you upload it.
Yes, and you lodge
You
it.
just
Yes.
upload the
You can now
documents.
bring the hard copy to us. Yes.
Okay, so the hard copy must be submitted.
Oh,
Yes.
the wills are stored in our office. Oh yes.
So what makes a will, that brings me to just a little bit of digression now. What makes a will valid? Can I sit in my living room and just look at, oh, I have so much now. I've built a house, I have this land here, I have these shares, I have these properties, and I feel that I need to write my will. Can I write my will by myself and have somebody that I trust witness it? Does it make it valid, or do I need a lawyer to write the will?
Let me answer it this way. You see, in many things, there's really no hard and fast rule. The only thing is, if there are certain rules or laws regarding a particular issue, then you must follow those rules. If you want to write your will, I don't think I've really heard of anyone, I'm sure it's just writing a will on its own. And most of the time, you call your lawyer. Most of the time. That doesn't mean it's not even possible. So what do you, Mobilani, I give this to that, I give this to that, I give to that, I cause to witness it. I don't see how it invalidates my will.
It is still a will.
Well, what is a will? W-I-L-L. What I will, what I want to give, what I want, this thing should represent my intentions, my interests. So really, except there is something, but of course, it must be witnessed by, in the presence of two people. So that's what I'm saying, that if there's laws guiding it, that this way should be, there should be that, but most of the time, 90%, 95%, we all call lawyers to do these things for us.
So the reason why I'm asking is that some people may feel that, like before this program started, I recall that we were discussing along the lines of a particular lawyer who took advantage of his client. The client had written his will and had made his intentions, expressly known. Yes. Unfortunately, the deceased, the man died, and all his children live abroad. Now, the lawyer is the one who knows the A to Z of what is contained in the will. And unknown to the children, the lawyer made some, there are bad eggs everywhere, as we all know, everywhere in the world. And, some of these assets were converted to the use of the lawyer. And then he somehow removed them from the will and laid claim to the property. Now, so where I'm going is this: there are some people who feel that I don't trust lawyers, I don't trust this, let me write my will myself, let me get somebody to witness it, let me lodge it with
there's no problem. Let me say something. So now, most of the time now you find people who have relocated. So it's a lesson for all of us. Even if probation, you don't even plan to relocate, but you don't know what will happen in the future. So when, like I said, there's nothing that says you cannot write your will yourself. Just make sure there's a witness. There are witnesses. And don't let those witnesses be people of your own age mates.
Yes.
That's a big problem for a lot of people now.
Because they may
but let me tell you
before
something. Even if that lawyer did that, you can go to court now, you can challenge it.
The case is in court
Oh,
as
yes.
we speak. Yeah.
So you can challenge it. Right? So you can challenge it. Let me tell you something. Even when we read our wills in the registry, excuse me, you see some faces, some sad faces, you see some happy faces.
Yeah.
Some, I tell you, they go to court to challenge it.
Yes.
So reading is a different matter entirely. Some will go to challenge it. Some will tell you that no, it wasn't possible. It was not the way Daddy wanted it. Some say it wasn't possible. And so many things. Because let me tell you something. When you open a will to read, you'll be amazed at what you see there. A lot of them are always amazed at what they say there. They'll be shocked. Somebody was telling me about someone who said that the man put there a particular girl, maybe that took care of him or something, that she should have some things in the property, so many things, you just wonder.
Yeah.
So you go to court if you're not satisfied. But importantly, please make sure that as you're writing your will, make sure that you have at least 2 witnesses make sure that there are people who are not your age mates. There are people who are easily accessible, so that when they are needed, they call
They
upon
make
them,
themselves available.
Yeah. And also, please, there's something we have seen. Don't go and make someone you don't know an executor. Let me give you an example. In fact, unfortunately, one of the children is a lawyer. So when we read the will, we find out that one of the executors is Mr. Folarin.
Oh, yeah.
They don't even know him.
He doesn't know. No relationship.
No relationship. So I asked the lawyer, who is the beneficiary of the estate? Because he's having problems now. Why? Because he says, Mr. Ayala says he's not doing. He doesn't even know you. So why go? Even though for some people, maybe they think because he's a popular name, so the person will be responsible, will help them manage their parties, but it doesn't matter. So now, he doesn't even know the person. Doesn't even know them. So of course he says he's not doing. The other two people, he don't even know where they are. So the person is stuck.
Wow.
So please be very, very careful. All those popular names, he's my pastor. Let me put his name. Make sure there are people that you know you can easily. If peradventure you relocate or you change from that church, you go to another church.
That's true.
What happens then?
So make sure that there are people that you know that you can actually get when you need them. Very, very important.
Okay.
Right.
So our time is fast spent, so we'll just go to a few more questions that now, I guess in the course of the discussion, we have talked about the heirs and the beneficiaries of the estate. So do you want to just throw more light on who the heirs are, who beneficiaries are? Most times people are confused about next of kin and a heir and a beneficiary, an administrator and an executor. People are confused about all these terms. So who is a heir, who is a beneficiary, and how do they differ from the administrator and executors?
And next of kin
also. And next of kin also.
Please, all that question. I just remember something I need to understand. Please, once you get your grant of probate, letter of administration, please, you're supposed to file accounts every year with us. If you don't, there's a penalty for it. A lot of people are having problems now. Let me tell you why they're having problems. I don't want to forget. Because it's in the law, and there's also something we attach to it. A lot of people don't look at it. The last page is there. File accounts every year. For some people, they want to get the money in the bank quickly. So they don't put properties now. Later, they come out for what they call additional assets. So now they want to bring the property in. Maybe time has healed, they are, whatever, the daddy died, now they feel better, they have enough money to spend. So now, some parties are there, they want to sell. Before you can't sell, because it's not in your name. So they now come back to us, we call it additional assets. So before you go ahead, before of all look at what you have. If peradventure you got your grant or letter of administration about 5 years ago, and now you want us to do something else for you, we'll look at, have you ever filed any account? If you are not filed, you're going to pay that penalty before you go ahead.
But madam,
yes. And it could be a lot.
Yeah.
Yes, it could be a lot. There are accumulated over
2 million, yes.
Yes, I think it's
100,000 per year now.
So the question that brings me to my next question. So now this individual left shares. Let's deal with shares only.
Yes.
Now all these shares, after the letters of administration or the grant of probate have been obtained, the shares have been transmitted, and we have sold the shares.
Yes.
We have distributed the money amongst the beneficiaries, and there's no more money. Why do we need to file accounts? I mean, that's one question I'm sure that why do we need to now start filing annual accounts? I mean, filing accounts
because that's what the
office every year, since we have already distributed all the assets amongst the beneficiaries.
And that's what the law says.
There's nothing else in the estate.
There is nothing in the. It could be a page, it could be a paragraph.
That's right.
Okay.
It could be a paper. There is nothing left in the estate. Everything has been distributed. It could be a page, it could be just a paragraph.
And that will still follow, we will still have to pay 100,000 to do that?
No, you're not paying to do it.
Default in
If you
filing.
default, you're not
Okay,
paying, you're
that
not
clears
paying.
it,
No. Because let me tell you something. You might still need us. You might still need government to do something for you. Because something can happen. Maybe somehow they give something to the disease somewhere. Maybe a school or something somewhere later in future. And if peradventure, and that thing is of course, maybe you need to, or maybe you just discovered something belonging to that person,
Yes.
which you didn't know about. Now you want to now use that thing. Of course, you can additional assets. So when you come to us and you have not filed your account, so that one you sort it out first before you do that.
Okay, the question I'm going to ask is, for how long will the filing be? Will it be to eternity? Will be filing every year till eternity? For how long
All
will
right.
the filing?
Okay. So I will get back to you on that because what Lord just said that you must file account every year. So that eternity thing, I think something I need to get back to you on.
All right.
Okay, so we have a couple of questions from our audience here. And one of the questions says that what is the role of KYC and background check in the probate management process, especially,
What's KYC?
KYC, know your customers, doing background check. What does KYC and background check have any, are they important,
Process,
in the process of obtaining grant of probate and letters of administration?
Well, maybe I need to really understand where that person is coming from. Because how do we background check in what?
Okay, now let me put it this way. You don't know the administrators, you don't know the executors.
Yes.
And now they are submitting to you documents
That's a very
requesting.
good. I was coming to that.
Yes. So
That's
how
very
do
good.
you ascertain who these people are? Do you do background check?
Yes, we do. For instance, let me give you a practical example. Recently, I got 2 people arrested. Okay, so this man died. 30-year-old man. The wife, 29-year-old, they have a baby. He died. Shortly after, the brother came and said, so when you come, the first thing we ask you, was the person married? Where is the wife? Where are the children? We must get to the root of that. That's the first thing. For us in Lagos State, I can tell you, you can hardly escape that. So he came. He said the man he wasn't married before he died.
Wow.
Okay. We started the process. When you're not even a witch anyway. You know what he says?
No,
My brother did this.
what they tell
I
you.
say, Shortly after, the wife came. The baby. So, of course, she had all the documents. Everything. She came. So, we already made our plans. Wanted that man to come back. You know, the brother came with a fake death certificate from General Hospital.
Wow.
All right. So the day he came, so when the wife came, we now told her to come back on a certain date. We told her to see the documents the brother brought. So the brother also came.
The brother of the disease.
Oh, the disease. Yes. So when he now came, I told them to sit down. Do you know this woman? He started stammering. Started saying all sorts, started telling me stories of what happened while he was sick in the hospital. Of course, I got them arrested.
Wow.
Oh, yes, I did. Oh, yes, I did. I got them arrested. Because so for us, you're very right. We make sure that we ask questions that by the time you finish answering those questions, if you are lying, somehow God being so good, that knows that you are lying, we will know. If out of 20, maybe you escaped 2. But yes, we do that. Because you must tell us where the wife is and where the children are.
So how then is it possible that as registrars, from our own end, we have seen situations where people who are not entitled to an estate obtain letters of administration and lay claims to being administrators, representatives of the estate. So at the end of the day, the original and the actual beneficiaries also come with
you need to
the same document.
You need to take each case on its own.
On its merit.
On its merit.
Yeah.
I'm telling you. Don't just say, oh, this they forged this. No. Let us take what happened in a particular case. For example, for a will, it's not really, it's almost impossible because the person would have named
The beneficiary.
the executors there.
Yeah, that's correct.
Whether the administration is a family. When you come, for instance, when you come, okay, I want to apply and I want those people to be the administrators. The first thing we ask you, who are they? Where is the wife? These days you are put there, is the wife there? Where are the children? So when we start asking you, before and the brother, no, we'll go ahead. And many times we don't even agree with them. You know what they do? I said, if you are not able to answer our questions, then please go to court. If the court now allows you to be the ones without the wife being there, and the children, then with the court order we'll go ahead. But without that, you must give us good answers to our questions. If you can't, we won't go ahead. So I want to know in which state. I want to know when did it happen, and why did it happen? For some, maybe the children are not around. Even in Lagos State, even they are not even around. For us, you can hardly get past that. I can tell you.
Okay,
honestly.
let me ask this
Oh,
question.
maybe give me a practical example.
Yes. There was a case recently.
Yes.
There are two different families.
Yes.
These families were not related.
Eh?
And the first one came with letter of administration to process transmission. And the other person also came with another letter of administration concerning
In Lagos State.
One from Oyo State, the other from Kaduna State.
Was there a resealing? Do you know what resealing is?
No. The fresh letter of administration from each of the states.
So did you write us? Because let me tell you something. When you get your letter of
We
administration,
do confirmation.
You want confirmation.
Yes.
The banks, landlords, anywhere. From different places we must confirm.
Okay. In this case,
Yes.
there was
Confirmation.
a confirmation from the Kaduna, from High Court in other states, in that Kaduna, that this is genuine, emanated from us. From the one in Oyo, also said
Not
yes,
in Lagos State.
No, not Lagos State. Is genuine and also emanated from us. Now, in that case, where registrar now, let's assume registrar now, treated one of it, and values were, given to the estate,
Yes.
dividends were paid to the estate, and the genuine family now came thereafter. Now, who has the liability? Is it registrar
Or the probate officer.
or the probate officer?
Well, I can only speak for my office. Number one, when you want to start your affairs in our office, there's an affidavit you depose to that there is no such process going on elsewhere.
Elsewhere.
So that is in your file.
Oh, okay.
In Lagos State. That is in place. You must depose that there is no surplus going elsewhere. That's why it's about resealing. If you have done in another jurisdiction and you come to us, maybe there's another property here which you can't do elsewhere. And you know what? So that we can call it resealing. So we do that for you good. So in Lagos State, I doubt it for us, and somebody will now bypass that. And you are not the ones entitled.
So that brings me to, audience, I hope you are getting some insight into the whole probate process and
because if
settlement.
you don't tell us where the people are entitled are, because going back to that your question, if you look at the law, ordinarily, that's what it dies. The person's asset, whatever, devolves on the person's representatives. Who are those? Who are those beneficiaries? Spouse, children, then parents, siblings.
Parents before siblings or siblings
No,
before
parents
parents.
before siblings. No, of course, spouse, children, parents, siblings, before that go to aunts and
External,
uncles. Oh yes. So if in Lagos State, if you don't convince us where the wife is, where the children are, you go to court registry. We send it to court.
Okay.
If you are not convinced, please let the court be the one directing us to decide. Yes.
Okay, so I quickly want to, falling as a fallout of the things you said now.
Yes.
We did talk about one state to another. Now, my question is this: is there any particular law that dictates which state a deceased estate's administrators or beneficiaries must be done. For example, what I'm trying to say is this. Somebody lives in Lagos, has his properties in Lagos. However, maybe he traveled to Abuja or to Kaduna and he dies there. Where does that person, where do his beneficiaries or his children, where do they obtain the letters of administration? Is there any law that requires that you obtain your letters of administration at so and so location?
Okay, that's a very good question. In Lagos State, in Lagos State, so the High Court rules of Lagos State governs probate under 60 to 63, you know, and we also have Lagos State law, addition of estate law, so for Lagos State. So really, if it's only money in the bank, anybody can do it anywhere. But if you don't reside, if you reside in Lagos, maybe you just went to Abuja for something, when you are needed to do something, how is it possible for you to come and do it? That's why most people, they do it where they reside.
That's right.
That's the easiest way for them, because you still come physically from one thing or the other.
Okay.
But if you have the property in Lagos, there is no way you can do it elsewhere. The same thing, we can't do for property in, even if we do for you in Lagos, and property is in another state, you can't put that in a way. It's not possible.
Okay. Viewers, we are going to take a break for a minute. We'll be right back.
I hope it's becoming clearer.
Yeah, it is.
It's a very simple, honestly, very simple process. Even all these people that you know that are not well read, PM or war, bring them. They will give you anything because it's small estates. Yes, because Can we? Can we? All right.
Give us a cue.
All right, so before we go ahead, please, I want our listeners to know that it's very simple to go through this process in Lagos State. And I mean it. Please all be responsible for this statement. It's very, very easy, very simple. Just walk in, come to us, either the Lagos probate or the Ikeja probate. Come to us. It's very easy. Even if you don't have a lawyer, come in, come to the registry. Just tell us why you have called, tell us you have lost somebody, and how do you go about this process. We'll put you through. It's not as difficult as it used to be. Thank you. Go ahead, madam.
Thank you. I'm going to put the next question to Barrister Aaron Adeoye. Now, from the registrar's perspective, what is the process of transmission? Now, Madam has told us how to obtain letters of administration, who the administrators are, the executors, the beneficiaries, the heir, and all that. Now, from your own perspective as registrars, what is the process of having the assets of a deceased individual evolved to his or her beneficiaries? What do these beneficiaries have to do to ensure that they give you all that you need to do the transmission?
All right, thank you, moderator. In first registrars, we have made it a whole lot easier. What we require is just some few items which the representative of the disease can readily provide. We'll be requiring that the representative of the disease provide us with the letter of administration from the court. We also require death certificate, and like the speaker said, we actually place reliance on the death certificate from National Population Commission. All right. We also ask for bankers' confirmation of signature of the administrators. You know, we also ask for if there are evidence of the shares or the dividend, or evidence of the shares that the disease has, maybe dividend warrant or certificate, we also ask for it. And we also ask for valid means of identification, that is the driver's license or the NIN, in some cases. So these are the requirements that we ask for, and we also make them pay, a transmission fee, So on completion of all this, we will then do transmission from our end, and the dividend of the disease will be paid to the estate account, and the shares will be moved to the CSS account of the estate. So that's it.
Thank you. Now, is there, from your experience, what are the challenges or the bottlenecks that can arise during the course of this process that may not enable, that prevent the beneficiaries from having quick access to the deceased estates?
Yes, most of the time we observe that those requirements, a lot of times the representative of the deceased do not provide all the requirements. So all this, like the speaker said, sometimes part of the requirement will be provided, and after a long time, you won't see them. And by the time they resurface, coming with part of so that, affects, the process. Another thing again is that most of the time, we go to the extent of, advising them also concerning how to go about, getting the requirements. Some of the time, we refer them to National Population Commission for the death certificate and all. So the challenges over the time is always that the representative of the disease are not always, in most cases, providing the accurate documents.
Okay.
Yeah.
Thank you. Part of the question from Dr. Toro Johnson here is the issue of fraud detection. So from the probate court perspective, how do you prevent fraud, or how do you detect fraud before it happens, so that those who are entitled to these assets are not robbed of their entitlement?
Okay, thank you. But so I need to know what kind of fraud. Okay, before I forget, please, the means of identification we don't allow. We don't take your identification card from your offices. We don't use that. It's either international passport, NIN, driver's license, or voter's card, a permanent voter's card. Issue of fraud. Okay. Well, I don't know, if you bring me your NIN as your piece of identification, and how do I detect from my office that it's not yours? It's not genuine. You see, for the way, what we detect, I don't know, that's what I'm saying, fraud in what way? What we do is the questions we ask you, the answers you give, we definitely make us know whether you are the right person or not. Honestly speaking, I can tell you, for us in Lagos State, by the time we ask you about 2 or 3 or 4 questions, and you don't give us any satisfactory answer, we won't even go ahead. Because it's so important for us that those who are entitled are the ones who are the ones processing this thing. And for some of them are not even around. You can give power of attorney to somebody on your behalf to do. It's your choice. But I can tell you that for us in Lagos, for you to be able to pass through us, and you're not entitled, like I said, for the wills, it's almost impossible because the person has named those he wants in the wills. But for the letter of administration, and you come, and you're not the ones, you must tell us where the wife is. You must tell us where the children are. But these are the first two, the spouse, the children, before we go to the parent. But there was a lady that died. Okay, the lady died. She said the child she had still a minor, and that she didn't even marry the man or whatever. So what they were pressing was for the deceased lady. So no husband, okay, fine. The child still a minor, fine. So it was the sister that applied. So before I got sister, where is the mom showed up? He showed up, and we were able to get the young girls, the child's birth certificate. We knew it was actually a minor. She was my son. So by the time we start giving you questions to answer, somehow it's clear whether you are the real person or
So
not.
I have a question. I have this is more or less like a complaint.
Okay.
Regarding the Lagos State Probate Registry website.
Oh, okay.
This individual, DEMYSTIFYING,
Okay.
says that she hopes that the website has been improved upon, that she had an experience where she filled the letters for administration forms and had to pay again as the initial payment could not be traced. So, what can you say to this?
When did she? When was this?
She doesn't state here when this was, but she says she has filled the forms online and made payments.
Last year.
Oh, last year she made payment and then she had to pay again because they couldn't trace the payments that she made earlier.
Can you please give her my phone number? I'm surprised.
Okay, so
I'm surprised if you have to. I'm surprised. Please give her my phone number. I apologize for that. I'm surprised.
So now, let's look at the Coroner aspect of your work. Before we came on stage, we were discussing the issue of people dying in questionable circumstances and what happens in such an instance. Where an individual dies in questionable circumstances, what remedies are available to his family or beneficiaries? To the extent that whatever asset he or she has does not get into the wrong hands.
Okay, so what she's trying to say is that, okay, I'm also a coroner in Lagos State. So what does the coroner do? The coroner investigates people, any suspicious death. That's what I do. When people die, and they die in, circumstances that are suspicious. So I do that. But the issue of coroner is separate from the issue of probate. So please know that. They are two different things entirely. So what does a coroner do? Somebody dies and you're not sure if the person died naturally. So you can come to us. In Lagos State, we have about 7 a coroner for each district. So I handle mainland, Yaba, mainland section, aside from Ikeja as a coroner. So most of the time, you go through the police. You lodge a complaint there. You report somebody has died. So the police will bring to me or to any other coroner some sets of forms to fill, to send to the pathologist at the hospital to do an autopsy. You know the reason why the person died. So if peradventure something happens and you lose someone who you feel did not die naturally, maybe a place of work, even in the hospital, maybe through the negligence of the doctor or whatever, please, you can lodge a complaint. The chief coroner sits at the Nomatosho courthouse in Ikeja. So that's where the office of the chief coroner is. So you can write a petition, you can write a letter there. The chief coroner, please, I want everybody to know that. Please, you can also go to the police station. So once you let the police know, the police will bring the forms, they'll bring to the coroner in that district to authorize the pathologists in the hospital to do an autopsy to know the reason why the person died.
All right, please, let me quickly shift this in.
Yes.
Magistrate court, customary court of appeal, do they have jurisdiction in probate matters?
Customary court of appeal is higher than the magistrate court. No, they are just like the high court. Yes.
Oh, they are higher than the magistrate court.
Customary court of appeal. Not customary court. Customary court of appeal.
Customary court of appeal and magistrate court.
Do they have
Jurisdiction.
Which one has jurisdiction over probate matters?
Letter of administration be gotten from customary court.
I'm not aware of that. I don't know. I can help you find out. I can help you find out.
Okay.
Because before customary court of appeal, oh yes, that's like a high court. I told you they are higher than magistrate court. Because I saw one, maybe I was reading something, I can't remember, and I saw one that was issued. Okay, no, I have to cite something, and I saw one issued by customary court of appeal in Oyo State. Yes, in Oyo State. Yes.
I
yes.
am aware of
So
Oyo State.
obviously they can.
I'm aware of
Okay,
Oyo
that's
State.
fine. I don't know how that kind of court operates. I don't know, but I saw one recently. High Court of Appeal, Oyo State. Saw one
Okay.
recently.
So you get back to us on the magistrate court and the
What did I say, court?
if magistrate court can issue letter of
Let me explain. Even the High Court issues the letter, but is the one in charge of it. So the High Court of Lagos, for instance, in its rules, is responsible for probate matters and also the laws of Lagos State, addition of estate laws. So there are two laws in Lagos State. There's one for probate matters, the High Court, Lagos State, addition of estate laws. Good. So the High Court has a registry, like an administrative court. That's what I heard. Do you get? So it's not as if it's inside the magistrate court that you go and collect the letter. No, it is the registry, which is under the High Court that has power over probate matters.
Okay.
Are you getting it now?
Yes.
Maybe because I'm a magistrate, maybe that's why you're looking at it that way.
Yes, we have had some arguments.
That-
Here, they said they brought letter of administration from magistrate court outside Lagos or customary court outside Lagos, saying no, because what we know is that
It is the
only
High Court that has.
Oh, definitely, your probate matters.
On
Yes,
probate matters.
of course. So
Okay.
the registry is like an annex of the High Court in Lagos
In
State.
Lagos.
So that's where the administrative process takes place. Yes.
Okay. So,
And the chief registrar is the probate registrar.
oh,
Oh yes.
Yeah, the
So
chief
I
registrar.
work under the chief registrar.
Okay.
Chief registrar is the probate registrar. But if you
Okay.
see all those letters, that's the signature of the chief registrar. You are
Okay.
seeing.
Okay. So, now let's take a look at this question.
Sorry, ma'am, before you go ahead, please, for those of us who are married and it's a good marriage, it's not a bad idea if your spouse knows your PIN number of your,
Phone,
no, apart from the phone, yes, phone
your
and
laptop, your computer,
what the card,
okay,
this
your
card,
accounts,
ATM card.
ATM card.
You know, it saves a lot. If for example, something happens, the person dies, even with that ATM card, you can still withdraw money. And honestly, yes, you can. Before you start doing all those other processes. Honestly. And also, if peradventure you start this probate matter and you know maybe you need money urgently, you can apply to the court
Yeah.
to restore the bank, maybe to pay some money, which is very, very urgent. Once the court orders, the bank will do it, even before you finish the probate processes. Yes. 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 When you are buying properties, having joint accounts, you are Mr. Adeoye. Let's assume what's your wife's name? Busola. Let's assume your wife is Busola. So it's going to be Mr. What's your own first name? Adeoye. Mr. Adeoye Aaron and Mrs. Busola Aaron. Aaron is your surname. His surname, okay. Mr. Adeoye, Mr. Aaron Adeoye and Mrs. Busola Adeoye. Not
the
Mr.
spouse
and
must
Mrs.
be named. The spouse must be named.
Please, it's very important.
Very important.
Even in your joint account, please, even in your joint account. And the joint account is better if one person can sign. Just have to both sign at the same time. If you have
Either
accounts,
to sign.
Either to sign.
Okay.
No, it helps you.
It helps a lot.
So you can be able to spend even some money, even be 100,000 of the default fees. It used to be less than that. So now it's 100,000. So just make sure every year you file in your account. You know, so there's no recent law. No.
So, Madam, what are the trends that you see in the probate administration process, for the future? What are some of the things that you envisage will make the process easier than it is now?
Okay. Maybe as technology advances, for instance, we never used to have online application. Now you can just sit down with your laptop, download your forms, load your wills online. Then when you have time, then come to us, So even as time progresses, I believe that we'll get better. Lagos is always ahead, and we're always looking ahead, forging ahead, making plans that can make our services better and easily accessible to people. For instance, as I speak to you now, we are even changing our internet in our office. We can make things faster for us. So in the near future, I can tell that like you know, you were asking me now that how come it can't be less than 4 months or something. Who knows? Now that 1, 2, or 3 years, who knows whether we can be able to do it in 2, 3 months?
Or even less.
Or even less. So let me just assure you, anyone who is there, whether you are literate or not, come to us at the High Court in Lagos State. That in case of Lagos Probate, we do it seamlessly, honestly speaking. Not as bad as it used to be. Things are getting better on a daily basis. Just walk up to us, tell us what you want. Even if you don't even know anything about it, even if you don't even understand what I've said today, come ask for me. I head the Lagos section. My colleague heads the Kenya section. Just come, we explain to you. And if you notice anyone doing what you think is not proper, be bold to tell us. We will serve you better. Don't be afraid that, maybe the HOD is not around, though. If I go and report this one now, next time when I come, he will attend to it. It doesn't matter. Be bold to report. If you don't, how do we serve you better? If I know, I'll know how to handle it. Please. Okay. So these things are easy now. Just come to us and you'll be able to get what you want easily. Thank you.
Okay, so I think this may help somebody.
Okay.
What alternatives to probate exist? And under what circumstances might they be preferable? Talking about if you don't want to go the probate way, what are the alternatives to that?
You don't have to go the probate way, but there's no alternative. Because you won't be able to
like living trust, having a trust, having, or things like that.
Let me tell you something. It's not even a must on you that you must go the probate way. But the thing is that there is no way you can be able to assess and be in charge of the access of the disease if you don't go the probate way. Because those documents, either the grant of probate or the LA, are the ones that will give you the power to be able to administer those things. So if you don't want to, okay, let me give you an instance. If peradventure, maybe for instance, you feel you don't even, there's no property, and you're able to access all the money, maybe like, the ATM PIN, the ATM card, the PIN, you can get the money, you have joint accounts, and a single person can sign everything, and there's no property, no problem. Why not? If I think I don't need, but somehow later, something might come up.
That will require.
That you can't, and if you don't have that document, so how do you want it? So there's no way you can stand somebody's shoes if you don't have the paper or the authority that gives the permission to stand that person's shoes.
Okay, so what I'm trying to get at is this. I know of some people in our society, very big names in the society that have put all their assets into a trust.
Okay.
Such that if and when they pass on, their children do not have to go the route of obtaining grants of probate or obtaining letters of administration. The old estates and all the properties are already in a trust. So how, that's
they are in a trust.
Yes.
But if you check the will, so that will be named, that trust corporation will be named in the will. They will come now because they'll be the trustee of the executor. It will be there.
Okay, so there's no way you can avoid.
Like if you say there is no way, I'm not sure we are saying the right thing, but it's just that. You don't want to, how do I put it? Because there's no way you will not, if something is not in your name. Okay, the person who puts everything in the name of the trust or whatever.
So what they call a living trust, what's a living trust then?
No, somebody can even, you don't have to even die before you create a trust.
That's what I'm saying.
Yes.
So if you have a trust,
yes,
and all your properties, your estate is in the trust, do you still need to obtain, do your beneficiaries still need to obtain letters of administration or grant of probate?
Okay, are you not saying
you now have
maybe,
board of trustees
okay,
who administer the estate?
Okay,
so you don't need.
But that means that the properties are already in the names of those children.
In the trust.
In the trust.
Yes. They created a trust.
For them?
For the family.
Okay.
So
it can work. I'm not saying it cannot work. Honestly, it can. But I'm saying that if peradventure the testator names that trust in his will, are you saying that trust will not still come to government to get it? It will come. Okay. There's no way.
Okay.
Yes.
So we have a question here from Olukorede Titilolu, Esquire. And I will address this question to Barrister Aaron Adeoye. How are disputed LAs handled by registrars? How can the registrar be a neutral party in dispute of LAs?
Before dispute of LA can arise, there must have been issues. There must have been an infraction somewhere, because ordinarily there can be dispute of LA. Meaning there are two LAs.
In all likelihood, maybe one party has obtained an LA, another party has also obtained an LA. I don't know if it's if it's possible to obtain two LAs for the same estate in the same state.
Okay.
Can that happen?
No. Like I said, in Lagos, it can't happen.
That cannot happen in
Let me tell you
Lagos.
something. Once you come to us and we start your process, number one, you must swear to David that this process has not started elsewhere. So let me give a practical example. So once you come and we want to start your process and you're registered, if it's already been done at our Ikeja section, it pops up. You either do it in Lagos section, so it pops up, it shows us.
Okay,
that
so you have a central
license,
definitely. So that there's no duplication of efforts elsewhere.
There's a man that came, his children, things are happening.
Yeah.
So please, let's put our houses in order. It's very, very important. So the man came, the children, two of the children were already processing the LA at the Ikeja section. So the man came to Lagos section to process the LA. Immediately we put it online. It showed us that
Somebody is already
on the same
processing.
diseased. So we had to put a stop. We had to have things on it and everything. So for us, it got centralized.
All right, for us in first registrars, where we have two different LAs, what we do is we advise the parties go to court. That's
The
what
court.
we do. Please go to court. So the court have the final decision on the determination of the right people that
Yes.
Yes.
And also, if peradventure there's an maybe it's not, maybe there are not even two, maybe only one, and you feel that the people who are there supposed to be there. Like there's one that came to my attention, was done in another state, and the person came and said it was in another state, so they wanted to add the properties in Lagos State to it. So they came to us, but they said what somebody is there, I'm supposed to. They said, okay, look, it wasn't done with us. It was done elsewhere. But at the end of the day, it's still the court that you go to go and complain. That yes, that's what I'm saying. The court is actually the probate, is the head of the probate. In Lagos, I mean, High Court is the head of the probate. So it's the court, just that the registry is the administrative part of the court.
Okay.
Headed by the chief registrar.
Okay, so on a final note, Madam, is there any difference in probate laws from one state to the other? Or, I mean, as a country, do we have differing probate laws, or can we rely on the fact that all the probate laws in each state are, in consonance, and that there are no variations?
And I can understand that. For Lagos State, I know. I don't know if, all I know is that most of the time people come to us in Lagos State to see what we do and to try to assist them to do in many things.
Okay.
So for Lagos, I don't know if it's the same other states have
In other
because-
jurisdictions.
in other jurisdictions.
Okay. So is there any question in the chat room? If you have your question, please let us know. We are coming to the end of the webinar for today. In fact, it has been such an insightful
Yes.
and interesting session. And we wish we can go on and talk more on this subject.
Anytime you want us to come back and explain more, we can. Anytime, because that's we are there. You, a lot of people don't even know we exist. There was a man that came to us. He actually came on the Coroner matter to me. So we got talking, and apparently he runs and maybe like an old people's home, or place where they keep people and they take care of them. And after they are gone, he's also responsible for the
Geriatric
and
home.
things like that. So And we started talking about this. He didn't even, I came there for a corona matter. He was shocked. He didn't even know. So a lot of people don't know. Please, we exist, we are in the High Court. Please come to us. It's seamless, and I must confess, honestly, it's not as difficult as you think. Once you do your own part by bringing the documents as a when due, then we have no problem.
Thank you so very much.
Thank you so much, Madam Folarin Williams.
Omobolanle Folarin Williams. So it's such a beautiful name that I don't want to shorten it.
Thank you.
So thank you so much for giving us your time out of your very busy, very, very busy schedule. We appreciate you taking out time to meet with us, to talk to our audience and to educate our people on the processes involved in obtaining grants of probate and letters of administration. For more inquiries, you may want to go to any of our social media handles on Instagram at First Registrars, on X, formerly Twitter, we are First Registrars, on LinkedIn, we are First Registrars and Investor Services Limited. You can also send us your email at info@firstregistrarsnigeria.com. Madam, maybe you want to also share your website once again so that if there's anyone out there
yes,
that
please. And also, please, Madam, anyone who wants my phone number, can you give it to them?
Okay.
So it's good for me to know.
Is it possible for the Lagos State Judiciary to work with us as registrars to integrate our system so that we don't have this issue of moving physical documents around? We can get direct information from your office transmitted to us online.
Okay, so I will take that.
That is one thing that we would really want to,
Very good.
on behalf of the industry, Institute of Capital Markets registrars that encompasses all registrars nationwide. We want to work with you to ensure that all our customers are served very well with little or minimal stress.
Yes.
We would appreciate it if we can integrate our systems.
All right, so I will take that back to the office. We'll look at that. But as of now, like I said, Mr. Adeoye, whenever you come, like I also, please, nobody is perfect. There might still be one challenge or the other we need to overcome. Please let me know so that we can work towards that. Let me know. It's better for us if we have these things done faster.
It
Better,
is
honestly,
actually,
makes people happier, and they don't.
even the revenue that we accrue to us will be, the more people know that they can come in and get these things done, the more they talk to other people. Oh, it's
yes,
easy.
it's
Go
easy.
there, you
Yes.
get it done, and it's all for everybody's benefit,
Yes.
both for the courts, for the registrars,
And
as well as the
entire nation,
beneficiaries.
beneficiaries.
On this note,
Before we round up this episode, I also want to say maybe we are going to charge Lagos State for making that party. Please, you can come through us for our probate and estate administration matters. First registrars, that's part of the things we do here, and we also handle secretarial services here. So please, maybe we are closer to you than the Lagos State government. So you can get to us, and where there's need to also get to Lagos State government or the Lagos judiciary, you can do that to us as well. So on that note, I think
on that note, we want to say thank you very much for taking our time out of your very busy schedule to be a part of this webinar this morning. We hope you have gained some invaluable insights into the probate administration and settlement processes, as well as transmission processes. And we look forward to serving you. So if you have any issues regarding your probate, procuring your grant of probate, your letters of administration, or transmission of your beloved one's shares, please feel free to get across to us on any of our social media handles or visit our office. We are located at number 2 Abebe Village Road, Igomu, Lagos. Thank you so very much for being a part of today's webinar. In another couple of months, we are coming back online with another topic of interest to you and to all our shareholders. God bless you and have a wonderful day.
Thank you.
All right.
Bye.